This podcast covers criminal law. There are two crime categories. The first is a misdemeanor. Misdemeanors are crimes that are less serious than felonies and are usually punishable by fines or short terms of incarceration in local jails. In Arizona, misdemeanors are punishable by up to 6 months in jail and are linked to a $2,500 fine and up to 3 years probation. The second crime category is a felony. Felonies are serious crimes that are usually punishable by imprisonment of more than 1 year or death. Examples include murder, rape, arson, and burglary, to name a few. In this slide, you see examples of misdemeanors. DUI, interference with judicial procedure, assault, trespass, criminal damage, etc. In this slide, you see examples of felonies: theft, aggravated DUI, aggravated assault, sexual offenses, drive-by shooting, and more. The states have police power to enact and enforce laws to protect health, safety, and morals of the people. The right of the states to make laws governing the safety, health, welfare, and morals is derived from the 10th Amendment, which states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." Police power is usually exercised when state legislatures enact statutes, and they also delegate much of their police power to counties, cities, towns, and villages. In 2020, the state's police powers have been a hot topic in the news following the death of George Floyd in May. President Trump threatened to send the U.S. military into the states, which saw many protests and sometimes violence. But the mayors of some cities and state governors have questioned the president's right to do so against their wishes because these cities and states believe that they have the right to handle the violence on their own pursuant to their police powers. Corpus delicti is Latin for the body of the crime. This is a legal principle that a crime must be proved to have occurred before a person can be convicted of committing that crime. Corpus delicti includes two elements. First is the actus reus, which is the commission of a prohibited act. For example, the actus reus for theft is the actual taking of or unlawful control over property without the owner's consent. It's the physical component of the crime. Second is the mens rea, which is the required state of mind. It might be intentionally, knowingly, recklessly, or negligently. For example, the mens rea for theft is the intent to deprive the owner of the property. The various mental states include intentionally, which means acting with a conscious goal or desire, knowingly, which means acting with a belief or awareness, recklessly, defined as acting with a conscious disregard of a known risk, negligently, defined as failing to perceive a substantial and unjustified risk, and strict liability, which means no mental state is required. For example, if one commits felony murder, she is guilty regardless of her mental state. This is a strict liability crime. Negligent homicide is defined as causing the death of another by creating an unreasonable risk. Professional negligence is an example of negligent homicide. This might occur where a doctor fails to follow standards of hygiene expected by society and his profession. When this breach of professional conduct causes a deadly infection in a patient, it can be argued that the doctor's negligence led to the patient's death. The doctor lacks malice and intent, but is otherwise responsible due to his negligence. Vehicular negligence is another example of negligent homicide. Vehicular negligence is negligence in the operation of any motor vehicle, from cars to boats and planes, which can result in the accidental death of others. Intoxication may be negligent homicide when excessive intoxication results in the unlawful killing of the victim, but there is a low assumption of mens rea as the accused lacks the malice and intent to harm the victim. The individual may be found negligent if his intoxicated state contributed to unsafe circumstances, as his recklessness is assumed to be atypical behavior and a deviation from the conduct of a reasonable person. Do any of you remember the Sweat Lodge case where James Ray was found guilty on 3 counts of negligent homicide? The participants, who paid nearly $10,000 to participate in a week-long spiritual warrior retreat, had stayed in an overheated, overcrowded sweat lodge. James Arthur Ray led that retreat. Prosecutors had sought to convict Ray on 3 counts of manslaughter. By finding Ray guilty on the lesser alternate charge of negligent homicide, the jury in effect decided that while Ray's conduct caused the deaths, he wasn't aware of or didn't recognize the risk of death caused by his conduct. In this case, the manner in which he ran the sweat lodge. There are 5 types of manslaughter: reckless killing, heat of passion, aiding suicide, coerced killing under duress, and killing an unborn child by injuring the mother. Conrad Murray was the personal physician of Michael Jackson at the time of the singer's death in 2009. Murray was found guilty of involuntary manslaughter for improperly administering the anesthetic drug that led to Jackson's death, and he later served 2 years of a 4-year prison sentence. Other examples of involuntary manslaughter include, let's say Eddie Hothead gets into a drunken argument in a bar with his acquaintance Bob Bonehead, and Hothead hits Bonehead over the head with a beer bottle, causing internal bleeding and death. He will be liable for and guilty, most likely, of involuntary manslaughter. Example number 2, Brent Bergel sneaks into a warehouse intent on theft and is surprised by a security man whom Bergel knocks down a flight of stairs, killing him. Notice here in this example, there is no murder weapon, which is why an involuntary murder charge is likely instead of a first-degree murder charge. However, if either man had used a gun, a murder charge is more likely in that case, since a deadly weapon would have been brought into the fact pattern or into the circumstances. The immediate rage in finding a loved one in bed with another, followed by a killing before the passion cools, usually limits the charge to manslaughter and not murder. But prior attacks could convince a district attorney and a jury that the killing was premeditated. A final example, let's say Lenny Leadfoot drives 70 miles per hour on a twisting mountain road, goes off a cliff, and his passenger is killed in the crash. Leadfoot can be charged with manslaughter. Second-degree murder can occur two ways. First, causing the death of another with either the intent to cause death or knowledge that death or serious physical injury would occur. Second, acting with extreme indifference to human life. You may recall the case from 2013 involving George Zimmerman, who was acquitted of second-degree murder and manslaughter. Zimmerman was acquitted of these charges related to the shooting of Trayvon Martin, who was a 17 unarmed black teenager when Zimmerman shot and killed him in a gated Florida community where Martin's father lived. Zimmerman claimed he shot Martin in self-defense during a scuffle. Zimmerman had faced charges of second-degree murder and manslaughter in the case, which also shed light on Florida's Stand Your Ground law. There are three types of first-degree murder. The first is premeditated, which means the defendant reflected on the idea of killing, if only for a brief period, and the defendant intended that her conduct would cause death. The second type of first-degree murder is felony murder. This is any death caused in the commission of or in the attempt to commit certain felonies. For example, burglary, robbery, rape, arson, kidnapping. The third type of first-degree murder is homicide of a cop. This occurs where the defendant caused the death of a cop in the line of duty and the defendant knew that the victim was a cop. Here are a couple of high-profile cases you probably recall. Jodi Arias was convicted in 2013 and sentenced to life in prison in 2015 for killing her ex-boyfriend, 30-year-old Travis Alexander. In 2004, Scott Peterson was convicted of the first-degree murder of his pregnant wife, Lacey Peterson, and the second-degree murder of their unborn son, Connor, in Modesto, California, and in 2005, he was sentenced to death by lethal injection. With regard to strict liability offenses, no mental state is required. This holds true for crimes such as felony murder, statutory rape, and DUI. A couple items to highlight in Arizona DUI law. Arizona Revised Statutes 28-1381, driving or actual physical control while under the influence. A talks about it is unlawful for a person to drive or be in actual physical control of a vehicle in this state under any of the following circumstances. And number 1 states that while under the influence of intoxicating liquor, any drug, a vapor-releasing substance containing a toxic substance, or any combination of liquor, drugs, or vapor-releasing substances, if the person is impaired to the slightest degree. Number 2 states if the person has an alcohol concentration of 0.08 or more, within 2 hours of driving or being in actual physical control of the vehicle, and the alcohol concentration results from the alcohol consumed either before or while driving or being in actual physical control of the vehicle. So what does all this mean? Simply put, one does not have to have a 0.08% blood alcohol content in order to get a DUI. If an officer finds an individual visibly intoxicated, for example, swerving, failure to pass the field sobriety tests, or just appearing disheveled and slurring words, etc., then that officer can award that person a DUI. So that language gives the officer a good amount of discretion. The language that if the person is impaired to the slightest degree gives the officer a lot of discretion. So take a look at that statute if you're interested in seeing it in yourself. That's ARS 28-1381. We are now going to talk about accomplice liability and parties to a crime. Parties to a crime includes principals and accessories. An accomplice. An accomplice is one who aids, counsels, or encourages the principal before or during the commission of the crime. An accomplice is criminally liable for the conduct of the other person. So an example of aiding might be helping the defendant flee from the scene, hiding the defendant, or hiding the evidence. The mere presence of a defendant at the scene of a crime, together with knowledge a crime is being committed, is insufficient to establish guilt. Inchoate offenses are underdeveloped or unripened offenses. These offenses are preparatory offenses and refer to activity or steps directed toward the completion of a crime. Inchoate offenses include attempt, solicitation, and conspiracy. Attempt requires an intent to engage in criminal conduct, the performance of an act that constitutes a substantial step towards the completion of the offense. Note that the attempt usually merges into the targeted crime once the crime is completed. For example, a person who is successful in an attempt to commit murder is often guilty of murder. Solicitation requires intent that an offense be committed. The solicitor commands, encourages, or requests another to commit the offense. The solicitation is complete when the request or enticement to complete the offense is made. It is immaterial whether the solicitee agrees to commit the offense. Conspiracy requires intent to promote or aid in the commission of the offense, agreement with one or more people that one will commit the offense, and one of the parties commits what's called an overt act in furtherance of the offense. Conspiracy is a separate and distinct crime, and it usually does not merge into the targeted offense. To learn about specific offenses, take a look at the supplemental materials on Canvas. We are now going to turn to discuss defenses. A person may use force that is reasonably necessary to protect herself from unlawful aggression. But if the person uses excessive force, then the privilege is lost. A person may use deadly force if threatened with imminent death or great bodily harm. There is no right to use deadly force if the harm is merely threatened at a future time, or the attacker has no present ability to carry out the threat. For example, A, who has his arms tied behind his back, says to D, "I am going to kill you." And then D pulls out a gun and shoots A. D cannot claim self-defense. Is intoxication a defense? Voluntary intoxication is not a defense. Involuntary intoxication is a defense. Thus, it is no defense that the defendant was not aware of or could not believe in the existence of conduct or circumstances solely because of voluntary intoxication. However, intoxication resulting solely from the involuntary use of alcohol or drugs may be considered in deciding whether the defendant had the mental state required to prove an offense. The degree of intoxication is relevant. So let's say bartender spikes defendant's Sprite, and defendant 5 Sprites later becomes violent as a result of this involuntary intoxication and punches patron A, resulting in defendant's arrest for assault. Now, the crime of assault requires an intent to cause harm. Defendant may be able to argue that the involuntary intoxication prevented him from forming the intent to cause harm. The defendant may be found guilty except insane if defendant was afflicted with a mental disease or defect of such severity that she did not know the act was wrong. The defendant must prove this defense by clear and convincing evidence, which means that it is highly probable. This is a high standard to meet. You are probably familiar with the Andrea Yates case from 2005. After Yates originally faced the death penalty for the drowning deaths of her 5 children, a second jury found her not guilty by reason of insanity. In the second trial, jurors deliberated for 13 hours before finding that Yates did not know her crime was wrong because of her long history of mental illness. You may presume, based on the news, that not guilty by reason of insanity is a highly successful defense strategy. This presumption would not be correct. In actuality, the insanity defense is used in only about 1% of all criminal proceedings, and its success rate is about 25% of that 1%. So less than about 1 in 400 defendants are found not guilty by reason of insanity in this country. What you see in the news is a very small sample of intensive coverage that leads us to believe that not guilty by reason of insanity is used often as a defense. However, based on the statistics, it is not, and when used, it is rarely successful. The defense of duress means that a reasonable person would have believed he was compelled to commit such conduct due to the threat of imminent death or great bodily harm if she did not commit the crime. The defense of necessity refers to a reasonable person who believes that the conduct was necessary to avoid some harm to society that would exceed the harm caused by the conduct. For example, throwing cargo overboard during a violent storm, if necessary to save the lives of the crew and other people on board of a ship, will not constitute criminal damage to property. On the other hand, throwing some members of the crew overboard in order to save the cargo would not be justifiable. The defense of entrapment is when law enforcement officers engaged in undue persuasion or inducement that cause the defendant to commit a crime she otherwise would not have committed. The defendant must prove this defense by clear and convincing evidence, a high standard to meet. Mistake of fact is a defense if it negated the requisite mental state. Note, mistake of law is not a defense. So, for example, if Adam is hunting in the woods and he shoots at what he reasonably believes to be a deer, in fact, it is Bob who is killed. Adam's mistake of fact shows that he did not have the state of mind required for murder. A defendant may claim the defense of infancy if she is under the age of 14, unless there is clear proof she knew the conduct was wrong. There are laws throughout the United States that allow people to defend themselves when threatened, but the latitude they have to do so varies from state to state. Many states have enacted stand your ground laws that remove any duty to retreat before using force in self-defense. It is important to understand that even states that have stand your ground laws, certain restrictions apply when it comes to using force in self-defense. For example, they may require that the threat of perceived harm is objectively reasonable. Arizona has a stand your ground law, ARS Section 13-411. The concept of double jeopardy means that a person cannot be tried or punished twice for the same crime. The prosecutor does not get a new trial for the same crime, no matter how bad the lower court screwed up. A straightforward example is Joshua is tried for burglary and is acquitted. The prosecution is unhappy with the outcome, but is constitutionally barred from retrying him for the same offense. Some of you may be familiar with the Curtis Flowers case. Curtis Flowers is a black man in Mississippi who was tried 6 times for the same crime by the same white prosecutor and always maintained his innocence. Flowers finally saw his charges dropped in the fall of 2020. He spent nearly 23 years in prison, much of it on death row, for allegedly murdering 4 people in a small town furniture store. The Flowers story was featured in the APM podcast In the Dark. How is it that the concept of double jeopardy laid down by the Fifth Amendment did not apply to the Flowers case? The reason is because Flowers was never acquitted of the murders. If he had been acquitted, the case would have been dropped. In the Flowers case, Flowers, in the first 3 trials, he was convicted, and then those convictions were later thrown out by an appeals court which ruled that the prosecution made critical mistakes. Each time the guilty verdict was essentially erased from the books and the case went back to the beginning. The next 2 juries in trials 4 and 5 never reached a verdict. They just deadlocked and the proceeding ended in a mistrial. After each one of these first 5 trials, the prosecutor in the case could have just dropped the case and the murder charges against Flowers, but instead chose to try Flowers again and again and again and again. Double jeopardy didn't apply because, in effect, Flowers hadn't endured 6 trials for the same crime. He just had a first trial 6 times. Thus, those rules of double jeopardy didn't apply. A hung jury is equivalent to a mistrial, and the defendant can be tried again and again and again. The statute of limitations refers to how much time a party has to bring a lawsuit. A prosecution must be commenced or started after one of 2 items: actual discovery of the offense or discovery that should have occurred with the exercise of reasonable diligence, whichever occurs first. There is no statute of limitations or time limit for homicides and serious sexual offenses. The statute of limitations for felonies is 7 years. The statute of limitations for misdemeanors is 1 year. Offenders are punished with the goals of retribution, deterrence, rehabilitation, and incapacitation. The idea behind retribution is to pay for a wrong, or an eye for an eye. The goal of deterrence is specific deterrence, which means to prevent that person from committing an offense in the future, and general deterrence, to prevent others from committing an offense in the future. Rehabilitation is geared towards changing the offender's behavior. Programs of assistance, both in person and on probation, are there to help rehabilitate the person. The question is, how well does rehabilitation work, as there is such a high rate of recidivism? Punishment of offenders achieves incapacitation. The offender is not in society to commit more crimes. What offenses are punishable by the death penalty? First-degree murder. This is the only offense eligible for the death penalty. Rape is not eligible for the death penalty. The death penalty has a 2-stage trial process, which includes: first, the jury determines guilt or innocence; second, the jury determines punishment. Stage 1 is the trial to determine guilt or innocence. Stage 2 is the sentencing to determine punishment, life in prison or death. The Arizona Supreme Court must review an appeal in a case in which a defendant received the death penalty. The Supreme Court shall review all death sentences, and on review, the Supreme Court shall independently review the trial court's findings of aggravation and mitigation and the propriety of the death sentence. And that concludes our podcast for criminal law.